Is it legal to use a smart watch while you're driving? Now, I'm going to caveat the whole of this video by saying that I don't think you should be using a smartwatch while you're driving at all for any reason, because the only thing that you should be using it for is possibly the time, but you should be able to see the time from any other instrument on your car or panel or whatever. So in order to answer this question more fully, we need to dive into the regulations and look at what they say and how they might apply to a device such as a smart watch. But before we do that, I am Daniel Shensmith, a barrister of England and Wales. If you enjoy my content, please do consider hitting the like button and subscribe, because that really helps my channel grow, and I really appreciate that. It does help my channel grow when you hit that subscribe button, because YouTube spreads it out to a wider audience. So with that said, there are no cases as yet that have definitively decided whether or not a smartwatch is caught within Regulation 110. That's the one for mobile phones. But we'll need to take a closer look at the regulations to really decide whether we think this regulation applies to smart watches, because Regulation 110 is very broad. And we also have to consider the purpose, the intention of Parliament when creating this regulation in the first place, because that is how a court is going to look at it if and when a case comes to court, which no doubt it will. And I suspect if it does, it will end up at the Court of Appeal for an authoritative and definitive ruling as to whether or not this regulation catches smartwatches. Let's go to the regulations. This is the amended version, so the law as it is in force for Regulation 110, the construction and use regulations. And starting with the offence itself, no person shall drive a motor vehicle on a road if he is using a handheld mobile telephone or a handheld device of the kind specified in subparagraph 4. Now, law tends to jump about a bit when we need to understand what it means. So I, as a lawyer, will usually go, well, what does that bit mean then? And then I'll jump down to subparagraph 4 before coming back to reading the rest. So if we jump down to subparagraph 4, it provides here the kind of device. That's the way I interpret it. It's not what's written, because it says the kind specified in paragraph 4. So the kind of a device that is referred in paragraphs 1b, 2b, 3b above is a device other than a two-way radio, because for reasons I will explain in another video, two-way radios don't come into this. They will come back to that. Lots of questions about that, so I promise I'll come back to that. Subscribe, and then I'll come back to it. Which, and this is the bit that's been amended and interpolated into this regulation, which is capable, rather than is performing, is capable of transmitting and receiving data. The reason that's important is it's capable of it. Whether it's doing it or not is irrelevant. If it is capable of transmitting and receiving data, whether or not those capabilities are enabled. So any device that can transmit or receive any data, whether that's active or not, that's the kind of device that is caught within this offence up here. So by that bit of the definition, a smartwatch is a kind of device that is capable of transmitting and receiving data in exactly that way. That bit is satisfied. It's the kind of device. However, it doesn't end there. It rarely does. The first bit of that I've satisfied is that it is the right kind of device. However, and obviously there's the exemptions for a genuine emergency and the being in a drive-through and so on. And so when we're looking at whether this regulation is contravened or not, we look at sub 6, which is gone a bit skewy on the screen here, but you can still see it. Sub 6 here. For the purposes of this regulation, a mobile telephone or other device. So at the moment we're talking, this does include a smartwatch, is to be treated as handheld. So just to make this clear, many different devices could transmit and receive data, but may not be handheld. But a device is going to be treated as handheld. So you could have a laptop for argument's sake, but if it's got to be handheld, it's a handheld device. So let's read this as it's intended. is to be treated as a handheld device if it is or must be held at some point while being used. So, just for argument's sake, if you're holding the phone, but it's not being used and you're not using it, then it's not caught because it's while being used. So if it is or must be in the hand, held at some point while being used, it is treated as being handheld. It sounds obvious, but you have to work through it step by step like that to determine. Now, a smartwatch, yes, it's the right kind of device, but is it handheld? This is the question that it would turn on if this ever came to court. If it is or must be held at some point while being used. Now, if it's on the wrist, now this is not a smartwatch, although it is solar powered, it's a very nice watch, but this is not a smartwatch. But, you know, is it capable of transmitting and receiving data? No, not in the sense that we think of. It's GPS, but there's nothing that I can actually do with that in the sense that this provides. But if it were an Apple Watch or an Android watch and it's on my wrist, the question therefore is, being on the wrist, does that make it handheld? Now, the argument will come about both ways. First of all, the argument that it's not handheld because it's on the wrist, it's not in your hand, your hands are free. So arguably your hands are free because it's on your wrist. But then the counter argument to that is if you put it across like this and you are doing something with it, does that make it handheld? Many people will argue that it does because your hand's tied up. You can't be steering with this hand and using the watch with the other hand. So does that make it handheld? That's the question that will eventually come to court because someone will get prosecuted for this, be given points for this. They will appeal it if they are so minded, as the chap that was filming the collision with his phone that resulted in this law in the first place. He was filming the collision and said, no, that's not caught within the rules. And it went to the Court of Appeal. And so this whole law came about to clarify, this is what we mean. And what they mean is all of these things here. Now, this is the using bit, while being used. So if you're using the smartwatch for any of these things, illuminating the screen, checking the time, checking notifications, unlocking the device, bearing in mind that the watch can now unlock the iPhone, bear that in mind as well. A good lawyer will pick that up and bring that to the court's attention. Checking, unlocking the device, making or receiving or rejecting telephone calls. You can reject a call by placing your hand over it. Is that using it? Well, yes, it is using it because you're rejecting a telephone call just by placing your hand over the watch. You're rejecting the call. But is it handheld? So any of these things will amount to using it. So it's the right kind of device. You're certainly using it if you're even just checking the time, illuminating the screen. So whatever you are doing with the smartwatch, you are using it. And it's the right kind of device, you're using it. But then, is it handheld? That's the only point. I can't definitively give you an answer because there's an argument both ways. The reason there's an argument both ways is if and when this eventually comes to court, the court will try to determine what did Parliament intend when creating this regulation? And is the wording of it sufficiently clear and determinative to incorporate and include a smart watch within that definition as a handheld device of the kind being used in this way? Now, there are arguments both ways, and I can give you both arguments both ways. I would probably lean towards, depending on what you're doing with it, if you are checking the time, I would say that it's not handheld for that purpose. If you are potentially even rejecting the call with your hand, I'd possibly say it's not handheld for that purpose. However, my view would change completely if you were dialing a call or looking for a contact within the phone in the directory on your watch, or certainly if you're typing a message and those kind of things on the smartwatch, my view will be that it is effectively, in the way that Parliament intended, it would be a handheld device for those purposes. Because, as I illustrated, this is not the smartwatch, but you are tied up. You are tying up the hand, which is the same effect as having a phone in your hand. So my view, the argument, if I were arguing this as the prosecutor, I would say you have effectively handheld by holding it here, the smartwatch, to use it with the other hand, just as you would a smartphone, smartwatch. The difference is minuscule. If I were defending it, I would say, well, no, my hands are free. I could have my one hand on the steering wheel and I'm tapping it with the other hand. So the hand is still on the steering wheel. So as many of these cases are, they might well come down to a very, very fine analysis of the facts. So it may well be that the court ultimately determined that if the hand is on the steering wheel and you've done something with the phone, then that might be okay. But I'd still lean, it depends on what you're doing. If you're cancelling the call and you've just got your hand on the steering wheel, I don't think there's probably a problem with that. If you are typing out a message, holding the steering wheel and just occasionally glancing over the steering wheel to see where you're going, I think that is caught within Regulation 110 because it's what Parliament intended to restrict. And unless and until a court determinatively and authoritatively decides whether it's caught or not, I won't be doing it. Now, I wouldn't be doing it anyway. But when I say I wouldn't be doing it, I mean, metaphorically, if I were you, I wouldn't be doing it. If you were really wondering, am I allowed to do this? Then perhaps you shouldn't be on the road, with all respect. With the greatest respect, nobody should be driving around typing out a message. That is as clear, and that includes being in stationary traffic, because you're not focusing on the road. It's a danger to yourself and others. And take it from me, as the barrister who's gone to court to argue over what the injuries are worth for a child as a result of a road traffic collision that are results of people losing their concentration because of using mobile phones. Take it from me, it is not worth it to even try to tap out a message, respond, even to some extent using the voice commands, activating them and that sort of stuff. And certainly not dialing calls and whatever. If you can answer a call with the press of a button and it's minimal distraction, then that's as far as I would take it. And I think that's as far as you'll get away with the regulations and the legislation. And to caveat all of that even further, regardless of whether it even comes outside of these regulations, you could still be held to be driving carelessly or without consideration of other road users. And if you cause a serious injury to somebody, that could amount to dangerous driving. So all of those caveats and the analysis, I come down on the side of just don't do it. There is no point in doing it. So unless, as I say, you are simply checking the time or rejecting a call, which does nothing but just tap the watch to clear the call, then I wouldn't be doing it. So I hope that answers the question insofar as I can. But as I say, until it comes to court, we won't know. But I suspect that when it does, it will be fairly heavily weighted on the side of the regulations to incorporate virtually any smart device within the regulations. I hope you found that useful. If you do, please hit the like button and subscribe. And as always, thank you for watching.